was torn apart. And no wonder the initiator...
There's a procedure.
But I rose procedurally, Madam Speaker.
No, I gave
procedure
you,
cannot counter procedure.
No, I gave you space to speak. Not
but I raised...
He has an order.
An order cannot... Honorable, you've been around for some time. You know that procedure takes precedence. You're going to mislead the new MPs who are coming in the 12th Parliament. They need to know and learn from people. Let me proceed in earnest, Madam Speaker.
But Honorable Lob, I want to put this on record that we do not have a new bill. We only have one bill. I am the custodian of the law in Parliament. If the President wanted to make a change in that, in the law, in the bill, the President ought to have informed me. I am not aware of that. It has not come to my attention. I am the one processing the bills here. So if he sent it for public, and if he called the chairpersons, he's one of the Ugandans whom we should consult.
Madam Speaker, I'm glad you're saying you were not informed, and that's part of the problem I'm raising. Why was this House not informed? Especially because majority of the clauses were amended. Madam Speaker, please protect me from noisy colleagues. You always tell us that this is not a market.
Colleagues, please let the Honorable Lob finish. Let Honorable Lob finish his submission. No. Honorable members, let's be calm. I am the custodian of the law here. I don't have a new law. I don't have a new bill. So after Honorable has finished, I will ask the minister to move his bill. You finish.
Thank you. So as I was saying, this is me saying, and you will rule and guide. For all intents and purposes, as far as I am concerned, this then became a new bill because majority of the clauses in the bill were changed. And there is precedents where ministers have been told, no, those so many amendments, just withdraw the bill and reintroduce it perhaps. What the Minister for Internal Affairs and Attorney General should have done was to withdraw this bill.
Honorable Lob,
but Madam Speaker, you're not even allowing me to submit.
Honorable Lob. Honorable members, you recall that on Wednesday 15th, 2026, the Minister of Internal Affairs tabled the Protection of Sovereignty Bill 2026 for the first reading. Pursuant to Rule 135 of the Rules of Procedure of Parliament, the bill was referred to a joint committee of Defense and Internal Affairs and Legal and Parliamentary Affairs. The committee has concluded the consideration of the bill and is ready to report. And pursuant to Rule 136(1) of the Rules of Procedure, I will invite the Minister to move his motion for the second reading before I will give you to bring your issue. Please. Honorable, let him first move, then I will give you to bring your issue. Okay?
Thank you, Madam Speaker. Madam Speaker, the bill you have invited this House to consider is a government bill. I saw a tweet by the head of government and a letter signed by retired General Yoweri Kaguta Museveni Tibuhaburwa.
Sabalwanyi.
That's not part of the names. So, in his letter, Right Honorable Speaker, he actually disowned...
Lob, is it in his letter?
Yes.
Can I
Let
have
me
a
submit, Right Honorable.
No, I want us to talk with evidence. Can we lay the letter on table?
I came prepared, Madam Speaker. Here is a copy of the letter. I am tabling it.
I have never seen a letter from State House in white.
Madam Speaker, this is a copy of the letter, and I am tabling it. Normally we table documents, then they can be processed and authenticated and so on. But let me raise the point I was raising, Madam Speaker. In this letter, he disowned the bill that was tabled by the Minister of State for Internal Affairs. In fact, he was appalled, wondering what it is that we were debating. Also, what bothered me, Madam Speaker, in his letter he said he called the two chairpersons of committees regarding this bill. I don't know how procedurally that gets to be correct, that now the executive gets to meddle directly, because it should be you, Madam Speaker, to call chairpersons of committees, guide them and so on. But if they are getting guidance from the executive, it's a problematic issue. Madam Speaker, the Attorney General and the Minister of State for Internal Affairs went back to the Joint Committee and they made amendments to majority of the clauses in the bill. Please note, for those who have been following, amendments to majority of the clauses in the bill. For all intents and purposes, Madam Speaker and colleagues, this was now a new bill. For all intents and purposes. And by the way, there is precedents that have been set by this House, even in the previous Parliament, where...
Honourable members, I want you to listen to Lope. Lope is saying, after...
Let me actually say what I am saying. I'm glad you are protecting me from some noisy colleagues.
This becomes a new bill. What I would only ask, did the new bill change the objective of the old bill? You continue.
Madam Speaker, and I'm glad you're asking that question, because the entire foundation of the bill was torn apart, and no wonder the initiator...
There is a procedure.
But I rose procedurally, Madam Speaker.
No, I gave
procedure
you,
cannot counter procedure.
No, I gave you space to speak. Not
but I raised...
He has an order.
An order cannot... Honorable, you've been around for some time. You know that procedure takes precedence. You're going to mislead the new MPs who are coming in the 12th Parliament. They need to know and learn from people. Let me proceed in earnest, Madam Speaker.
But Honorable Lope, I want to put this on record that we do not have a new bill. We only have one bill. I am the custodian of the law in Parliament. If the President wanted to make a change in that, in the law, in the bill, the President ought to have informed me. I am not aware of that. It has not come to my attention. I am the one processing the bills here. So if he sent it for public, and if he called the chairpersons, he's one of the Ugandans whom we should consult.
Madam Speaker, I'm glad you're saying you were not informed, and that's part of the problem I'm raising. Why was this House not informed? Especially because majority of the clauses were amended. Madam Speaker, please protect me from noisy colleagues. You always tell us that this is not a market.
Colleagues, please let the Honorable Lope finish. Let Honorable Lope finish his submission. No. Honorable members, let's be calm. I am the custodian of the law here. I don't have a new law. I don't have a new bill. So after Honorable has finished, I will ask the minister to move his bill. You finish.
Thank you. So as I was saying, this is me saying, and you will rule and guide. For all intents and purposes, as far as I am concerned, this then became a new bill because majority of the clauses in the bill were changed. And there is precedents where ministers have been told, no, those so many amendments just to withdraw the bill and reintroduce it perhaps. What the Minister for Internal Affairs and Attorney General should have done was to withdraw this bill.
Honorable Lob,
But Madam Speaker, you're not even allowing me to submit.
Honorable
Let me
Lob,
submit. You're the one going to rule.
please, Honorable Lob, my brother. Honorable Lob. Honorable Lob. Honorable Lob. Can I have order? Can I have order? We have now started debating in anticipation. We don't know what the bill is. When the minister moves his bill, that's when we can reject. Huh? Please make my work easy. No, you leave Honorable Lob to finish. Switch on.
Madam Speaker, actually I am seeking to make your work easier. Really, if you capture what it is that I'm saying. Because they are moving it for the second time. And for me, what I was saying is you should have been moving to withdraw the bill. That's my opinion. And you're going to give your ruling, Madam Speaker. So, no, but they called for reading of the bill for second and third reading.
Okay.
So, let me finish the issue that for me I am raising.
Okay.
Madam Speaker, also,
What
stakeholders...
What is the procedural matter that you are raising now?
So, the procedural matter I'm raising is, should the Minister of Internal Affairs be withdrawing his bill, and then he goes back for consultation.
Can I answer
Finally.
that first? Can I answer that first? Maybe it will form your second question, that the Minister of Internal Affairs should be moving his motion for the second reading. Because as far as I know, I have not been given another motion. I only have one motion. So you will move your second motion for the second reading.
Thank you, Madam Speaker, and I'm glad on record you have said you were not notified of a second one. That's something we are going to interrogate, because like I'm saying, as far as some of us are concerned, it's a second one. Right Honorable Speaker, the committee report to this bill here leaked, and it is in the public domain. It was first shared on our Parliament platforms. Media houses have shared it. It is all over. Honorable Speaker, on 18th of January 2023, you were seated in the chair you're seated in, and I was standing on this very microphone. I was chairperson of COSASE. I rose to present a committee report for COSASE on Uganda Airlines. And you said, Right Honorable Speaker, I want to quote you verbatim what was on the Hansard. You said, there was a leakage of the Uganda Airlines report. A property of this Parliament cannot leak, and we continue debating on it. Those were your exact words captured on the Hansard. Honorable Speaker, this report has leaked. So, given that precedent which you said, are we going to go ahead and debate this leaked report?
Thank you.
Because the precedent was set by yourself. We hope to be ready.
First of all, honorable members, in the VIP gallery, I want to introduce Honorable Namlondo Sara, MP-elect from Buyende. You're most welcome. Honorable Naku Fiona, the elect for workers. Most welcome, Fiona Naku. And then we have Honorable Sewagude Robert, representing people with disability, national. You're also most welcome. I have Honorable Matembe, Miriam, and Honorable Emily Otekat. Honorable members, I want to refer you to Rule 14. The report of the Committee on Bills shall, and I'm saying shall, be uploaded on the Parliamentary Information System for the information of members before the report is laid on table. That is 214.14a. This report that was uploaded had my signature. I even said, please place it on the order paper with my very able signature. The report of airlines that got out did not have my signature. I am the only one who can sanction a document to be uploaded, which I did, so the report was not leaked out. Can you move your motion?
Right Honourable Speaker and Honourable Members, in keeping with Rule 130 of the Rules of Procedure of this Parliament, I beg to move that the bill entitled the Protection of Sovereignty Bill 2026 be read the second time.
Seconded by the Vice President of Republic of Uganda, Honorable Jessica Alupo, retired. Honorable Prime Minister, Honorable Nabanja Robina, Honorable Second Hajat, third Government Chief Whip, Minister of Defense, Minister of Security, Minister of ICT, Minister of Finance, Minister of Works, Minister of Sports, and the Hollow House on this side. And part of that house, part of the other side, including Chemongesi, Rogomayo. Thank you. Would you want to speak to your motion?
Right Honourable Speaker and Honourable Members,
can I first have a justification before you bring the procedure?
Right Honourable Speaker and Honourable Members, the object of this bill is that the country faces a number of challenges which threaten our ability to self-govern in the absence of a sovereignty-specific law which this law seeks to address. And these include preventing undue external influence, regulating foreign funding, safeguarding national security, filling legal gaps, and managing digital misinformation. I beg to move, Right Honourable Speaker.
Thank you. Honourable members, I want to provide some guidance in this. Honourable members, the chairpersons of the committees have prepared the report, and I wish to guide as follows. From the time the bill was tabled for the first reading, there has been a very remarkable public interest in it. A review of the committee report reveals that more than 60 witnesses were accorded opportunity to present their views on the bill, including persons and institutions. These answers and questions on whether there was sufficient public consultation or not, I commend the committee for upholding our cardinal principle of public participation. 2, there was a considerable debate on the content of the bill notably the definition of the word foreigner, the scope of application of this bill, the regulatory prudence envisaged in administration and functions, the proposed penalties, the criminal offenses, regulations of foreign policies, registration of agents of foreigners, declaration of foreign funding, and ministerial powers, among others. I have reviewed the report. The committee has established that the contentious matters have been exhaustively handled and addressed as per the public interest. The definition of a foreigner, for instance, was initially brought in a way that was not appealing to the people, but the committee has handled. Now I want members, there's no procedure, I'm giving you guidance. I know I'm touching on your minorities. Honorable members, I am giving 30 minutes for the major report to be presented, and I am saying 30 minutes. Where is the chair? And I will also give, I am aware that is a minority report. It doesn't matter whether minorities or minority. I am also giving the minority or minorities 30 minutes. If you have 10 minorities, you'll divide 30 minutes by 10 and you'll have 3. Honorable Chair, unanswered, I want timing. Let him read his report. Then you will bring process. I don't want you to waste his time. Tebandeke, I know you want to exercise your law that you're learning now. You first wait. First wait. First wait. First wait. I have given you 30 minutes.
Thank you. Right Honorable Speaker. Right Honorable Speaker, for the record, my name is Wilson Kajrenje, Member of Parliament, Nyabusho's constituency, and Chairperson of Defense and Internal Affairs Committee. I'll be assisted by my colleague, the Honorable Baka Stephen Mugabi, Chairperson, Legal and Parliamentary Affairs. May I take the honor to lay on the table the minutes of the committee, the joint committees, while processing and considering this report.
Thank
But
you,
Honorable Speaker, indeed, I'll take the 30 minutes. But Honorable Speaker, on Wednesday, 15th April 2026, the Protection of Sovereignty Bill 2026 was read for the first time under Rule 135(1) of the Rules of Procedure of Parliament. You referred to the joint committee made up of Committees of Defense and Internal Affairs and the Committee on Legal and Parliamentary Affairs for scrutiny, and we are now reporting under the same rule of procedure. Right Honorable Speaker, the joint committee here referred to as the committee has examined the bill, taking into account submissions from stakeholders, and now presents this report. This report sets the committee's analysis of the bill's objectives, the key provisions, likely effects, together with the synthesis of stakeholder views and the committee's recommendations to Parliament. The object of the bill. The object of the bill is to enact a law that seeks to provide for the protection of the sovereignty of the people of Uganda. 2, to designate the department responsible for peace and security and the responsible entity for the registration and regulation of agents of foreigners. 3, to provide for the protection of the sovereignty of Uganda and provide for the registration of agents of foreigners, and to regulate the funding and any other assistance to agents of foreigners and for the related matters. Defects in the existing law. The bill identifies principal defect in the existing legal framework as the absence of a specific law operationalizing the protection of Uganda's sovereignty, which has allowed continued external interference in the government policies and programs. In particular, it points out the increasing influence of foreign actors and their agents in shaping policy and development priorities, often through conditional grant, conditional funding, and parallel programs that conflict with the national objectives. It further highlights inadequate regulation of civil society organizations, especially those receiving foreign funding, leading to concerns about transparency and alignment with the national objectives. Additionally, the bill notes the growing use of digital platforms by foreign actors to spread misinformation and incite social discord, collectively undermining Uganda's ability to self-govern independently and safeguard its political, economic, and social stability. Right Honorable Speaker, what method did we use? Methodology. In considering the Protection of Sovereignty Bill 2026, the committee undertook an extensive and transparent stakeholder engagement process to ensure broad participation. Public notices were published in the dailies, Vision and Monitor, on 17th April. We invited memoranda and views from all interested parties. This was to facilitate meaningful input. The committee suspended the sittings for 1 week to allow stakeholders adequate time to prepare and submit written memoranda. Upon resumption on 24th of April, Right Honorable Speaker and Honorable colleagues, stakeholders who had expressed interest were accorded opportunity to present their views. The committee engaged them directly, seeking clarifications where necessary. In total, and this is unprecedented, Right Honorable Speaker and Honorable colleagues, in total, the committee interfaced with 224 stakeholders, clustered under 60 groups drawn from diverse sectors. In the diaspora, the Global Forum Uganda Diaspora Council, whose memoranda included views of Ugandans drawn from 32 countries across all regions that gave their perspectives on the bill. In addition to the hearing from stakeholders who appeared before the committee also took into account the perspectives shared by His Excellency the President in his guidance to the nation through his letter, particularly that was addressed to the Bazuku regarding the bill. Following these engagements, Right Honorable Speaker, the committee held further sittings during which the learned Attorney General responded to the stakeholder concerns and proposed refinements to the bill. The interactive process ensured that the review incorporated both legal scrutiny and practical implementation considerations. This structured approach, characterized by open invitations, dedicated submission time, inclusive hearings, responsible dialogue, demonstrates that the committee's work was informed by a wide participatory and national representative consultation process. The stakeholders the committee interfaced with include the following. It is important, Right Honorable Speaker, that this goes on record. We have clustered them like this. We had stakeholders under government and public institutions. These are actors with statutory mandates that include Bank of Uganda, Financial Intelligence Authority, National Planning Authority, Uganda Human Rights Commission, the parliamentary committees. We also had another cluster of legal and professional bodies and organizations that focused on the law, like Uganda Law Society, like East African Law Society, the Law Development Center, Center for Constitutional Governance, that had in their entourage former members and former ministers of government. Independent legal and legal practitioners who forwarded multiple submissions. We had political actors and movements, political parties, or politically affiliated formations. These include Alliance for National Transformation, Forum for Democratic Change, National Unity Platform, the People's Front for Freedom, and for the record, the Hansard must capture this, Right Honorable Speaker, that Uganda People's Congress appeared and gave their views, and that the leader of opposition also appeared and gave his views. I'm mentioning it for the capture of the Hansard. We also entertained private sector and business associations that include the Chamber of Commerce, Kampala Arcade Traders Association, Kampala City Traders Association, Uganda Small Scale Industries Association, Uganda National Traders Association, the Gen Z Business Owners Association, Innovation Village, the startup ecosystem, and the independent private sector consultants. We did not stop there. We entertained financial, insurance, economic sector actors. These include the sector-specific institutional stakeholders that include Uganda Bankers Association, supervised financial institutions like banks, mobile money operators, via sector submissions. We also entertained Payment Service Providers Association. We also entertained Uganda Forex Bureau and Money Remittances Association. They too appeared and gave their views. We also considered digital, telecom, media actors in communication, broadcasting, and digital economy, include communication sector operators, National Association of Broadcasters, media practitioners, journalists, and journalism practitioners. We also entertained the civil society and non-government organizations, both domestic and international civic actors that include Anti-Corruption Coalition of Uganda, Foundation for Human Rights Initiative, Legal Aid Service Providers Association, the Rotary of Uganda, Women Pro Bono Initiative, Country Directors of International Network, and various national NGOs also submitted. We also entertained international organizations and development actors under these multinational organizations and international cooperation actors. These include United Nations Country Team, international NGO community, collectively represented. We did not stop there, Right Honorable Speaker and Honorable colleagues. We entertained the labor, religious, and social institutions that include NOTU, that include Interreligious Council of Uganda, that include Muslim Organizations Coalition, and other faith-based organizations. We entertained health, scientific community, and public health research institutions, e.g., Uganda Medical Association, Uganda Virus Research Institute, Peoples Living with HIV advocacy groups. We also entertained education and academic sector that include Makerere University Academic Staff Association, universities and academic researchers, student groups and members of the guild also submitted. National Union of Disabled Persons of Uganda, Uganda Lawyers Voice on Climate Change, Gender Rights and Advocacy, Climate Advocacy groups. We also entertained diaspora, transnational communities, Ugandan actors, the Global Forum. This is an organization that groups all Ugandans in the diaspora. The Cheyo Association, NUP, NUP Diaspora Chapter, individual diaspora submissions. We went further and entertained professional and individual submissions. These are unaffiliated and cross-cutting. Independent consultants, individual citizens, business professionals, researchers. Right Honorable Speaker, we consulted documents. Consequently, the committee recommendations reflect a balanced synthesis of stakeholder perspectives in the key findings and salient observations. Right Honorable Speaker, permit me to present key findings and salient observations on the Sovereignty Protection Bill of 2026. Introductory consideration, looking at the scope and interpretation of Clause 2. Before presenting its findings, the committee found it prudent to clarify the key interpretive issue of Clause 2, which is application of the bill. Clause 2 sits at the core of the legislative framework, and it defines the reach of the law and it determines who is regulated and what circumstances and for what conduct. The committee reviewed the Honorable Attorney General's comments, noting that Clause 2 limits the bill to specific activities tied to foreign influence. According to the learned Attorney General interpretation, the bill does not apply to persons generally, to all persons generally, that it applies only to persons acting as agents of foreign actors, and that even then, only where such a person is engaged in specific conduct, including influencing government policy, political processes, or public decision-making for the interest of foreigners. The Attorney General clarified that Clause 2 is meant to limit the bill, not to expand it. He guided that it applies only to agents of foreign actors and only when they engage in specific influence-related activities, e.g., affecting government policy, policies, or public decision-making. In addition, the learned Attorney General noted that the bill is activity-based, not identity-based. So ordinary transactions like remittances, businesses, family support are excluded unless tied to regulated influence. On this reading, the bill presented a targeted regulatory instrument aimed at structured foreign influence operations rather than legitimate international engagement. However, the committee observes that this interpretation, while persuasive as a matter of policy intent, is not shared by the majority of stakeholders. There is a gap between the AG's intended narrow scope and how the bill is actually drafted. When Clause 2 is read together with broad definitions in Clause 1 and the expansive list of activities, including concepts such as influencing public opinion and activities that the minister may prescribe, stakeholders interpreted the bill as having a much wider practical effect. The East African Law Society, for example, in their submission, warned that the term agent of a foreigner in Clause 2 could apply to regular economic, professional, and family connections, such as employees of foreign businesses, traders, and those receiving support from relatives abroad. The Law Development Center noted that that Clause 2 does not distinguish harmful actions from lawful ones. So the people could be held liable simply because of their associations, not because they caused any actual harm. This divergence, Right Honorable Speaker and Honorable colleagues, reveals a fundamental issue. The intended limitations of Clause 2 are not sufficiently clear on the face of the law, creating uncertainty as to the boundary between harmful foreign influence and legitimate activity. While the Attorney General maintains that Clause 2 limits application to specific regulated activities, stakeholders consistently note that this limitation is not clearly reflected in drafting. Therefore, the committee found that the line between harmful foreign interference and legitimate activities is unclear. Clause 2 is meant as a safeguard, but not effectively to limit the bill. This gap policy and the law shapes all the committee's subsequent findings. 5.2, understanding sovereignty. We looked at what the 1995 Constitution says versus what the bill proposes. Sovereignty under the 1995 Constitution as amended. This committee discussed sovereignty referencing the Constitution of the Republic of Uganda, herein refers to as the Constitution. The committee found that the 95 Constitution determines the sovereignty, that sovereignty belongs to the people of Uganda and not government. Specifically, Article 1, which states that all power belongs to the people who shall exercise their sovereignty in accordance with the Constitution. Article 1.2 adds that without limiting the effect of Clause 1 of this article, All authority in the state emanates from the people of Uganda, and the people shall be governed through their will and consent. These provisions establish that the people are the original in the protection of the Sovereignty Bill 2026. The committee further notes that sovereignty has two dimensions: a popular one, where power ultimately rests with the people, and security dimension, where the state exercises authority to safeguard national interest. We looked at a leading jurist, Justice Oliver Wendell Holmes, Jr., 1841-1932, a renowned American jurist who served as a Supreme Court judge, who described sovereignty in similar terms. Justice Wendell Holmes perceives sovereignty as the ultimate practical power of the state to govern and maintain order grounded in the historical and social necessity for societal existence and survival. The state action is therefore legitimate only when it maintains grounded in popular sovereignty. Guided by this understanding, Honorable Speaker and Honorable colleagues, the committee observed that the bill introduces a strong emphasis on shielding Uganda from foreign influence and expands the state's regulatory powers over political and civic activity. Summarily, the bill aims to protect the sovereignty of the people, prevent foreign interference on governance, and the key features include restricting activities that promote foreign interests, which can be gotten from Clause 5, restricting non-state actors from performing government functions, which is Clause 6, criminalizing interference in elections and government operations, which is Clause 1 to 13, and regulating foreign funding and civil society activities, and restricting interference.
Is it 1 or 11 to 13?
11, I beg your pardon. 11 to 13. Restricting interference of government policy. The committee, therefore, found that the Constitution grants ultimate authority to the people, with the government acting as a trustee. The Protection of Sovereignty Bill 2026 regards the state as primary guardian of sovereignty and adopts a cautious approach to foreign-linked actors. Whereas the Constitution vests sovereignty in the people of Uganda, the bill focuses on the protection of sovereignty through state action, reframing sovereignty in the security terms and promoting stricter regulation of foreign influence. We looked at broad definitions and the scope. The committee found that the bill definition of foreigner and the agent of a foreigner are overly broad. And as defined in the bill, it wrongly includes Ugandans living abroad. It wrongly includes students. It wrongly includes researchers. It wrongly includes professionals working in international partners. It wrongly includes government ministries, departments and agencies exercising regulatory authority under any act of parliament, and organizations and companies that simply have foreign investors or cross-border businesses. Instead of targeting harmful foreign interference, the bill inadvertently ends up covering normal economic, academic, and community activities. This, Right Honorable Speaker and Honorable colleagues, blurs the line between harmful foreign interference and ordinary lawful activities, it making everyday economic, academic, and civic engagement legally risky. Clause 1 and 2 are specifically powerful in determining who is regulated and punished. and even raising constitutional questions about citizenship by classifying Ugandans abroad as foreigners. Stakeholders warned that this could criminalize normal cooperation, such as research, education, and diaspora support. In fact, the Law Development Center has termed it as regulatory contamination, where indirect foreign links extend liability across entire economic and social chains. The committee therefore recommends, 1, that to restore legal precision, to ensure proportionality, and to align the bill with constitutional principles and practical realities, the committee recommends the following. Amend the definition of a foreigner to limit it to non-citizens and foreign registered companies. Amend the definition of agent of a foreigner to only include people who formally and knowingly act on behalf of a foreigner to influence public policy, elections, or national security. Insert new definitions of words and phrases used in the bill to improve clarity. Insert an intent requirement, which the land colleagues call mens rea, so liability only arises with deliberate influence. 5. Insert a clause explicitly protecting legitimate economic, academic, humanitarian, developmental, and civic activities to prevent misinterpretation and ensure lawful activities are not captured by the bill. 5.4, creation of a parallel regulatory regime. The committee observed that the bill creates a new approval and monitoring system under the Ministry of Internal Affairs. However, many sectors in Uganda are already tightly supervised by strong regulators, these include Bank of Uganda, Financial Intelligence Authority, the Uganda Communications Commission, Insurance Regulatory Authority, and university councils. Stakeholders argued that the bill repeats work already done by these regulators and may create conflicting rules instead of improving oversight. This duplication can lead to confusion about which rules apply, multiple reporting requirements, and uncertainty for businesses and institutions. For example, both telecommunications and banking sectors already operate under strict regulatory systems. Adding another regulator with similar powers could disrupt systems that are currently functioning well. The committee notes that these sectors are already governed by detailed laws and licensing frameworks. Stakeholders also warn that the bill could create a parallel system, quote unquote, run by a security-linked department that may not have technical expertise of existing regulators. Media organizations, too, pointed out that the issues such as foreign funding, transparency, external influence are already addressed under current laws, including anti-money laundering legislation and the NGO regulation. The private sector representatives highlight the economic impact of the bill, more uncertainty, more regulators to certify, and higher costs of doing business. Stakeholders caution that the bill risks creating duplication, institutional conflict, and opportunities for forum shopping. The committee recommends, therefore, that in light of these concerns, the committee recommends that all institutions and individuals already supervised by a regulator established under an act of parliament should be exempted from the bill. Concentration of executive power in the minister. The bill gives the minister responsible for internal affairs wide and layered powers. These include authority to 1, define the key terms used in the law, 2, approve or reject the foreign funding, 3, register or cancel organizations, and determine how the law will operate through regulations. The committee notes that while each of these powers may be common in isolation, their combination in a single office creates a system where participation in economic, civic, or institutional activities depends heavily on the minister's approval. This raises deeper constitutional concerns not just about administrative efficiency, but about the overall design of governance. The committee elaborates these issues under three major themes, from regulatory oversight to discretionary control, where stakeholders observed that the minister's power and the role goes beyond implementing the law. The minister effectively controls access to the law itself, and the minister can decide who falls under the law, who controls access to funding, grant or withdraw legal status, and shape how the law functions in practice. This, we noted, it risks turning the framework into permission-based system where individuals and organizations must seek approval to operate instead of following clear, predictable rules. It also has constitutional implications. This concentration of authority raises significant constitutional concerns. It weakens the separation of powers by placing too much control in one office. It reduces checks and balances from independent institutions. It increases the risk of unfair or arbitrary decisions, especially where the bill lacks clear procedures, timelines, or appeal mechanisms. A system that relies on discretion rather than clear rules undermines legal authority. No, I beg your pardon, undermines legal certainty and public trust. We also looked at reframing sovereignty. The committee notes that many legal and governance submissions view this more than an administrative matter. They see it as a shift in how sovereignty is exercised. Instead of power flowing through established institutions and the people, it risks being concentrated in one single office. From human rights perspectives, any limitation on rights must meet three tests. 1, legality, necessity, proportionality. The bill does not clearly demonstrate how these standards are satisfied. We therefore recommend, the committee recommends that to preserve the bill's objective, I beg. Can I conclude? Thank you. Let me read. Thank you, Right Honorable Speaker.
How many minutes do you want to conclude?
Yeah. I need 5 minutes and I conclude.
5 minutes. I'll add the other side also 5.
Okay. The committee recommendations. To preserve the bill's objective while restoring institutional balance and constitutional compliance, the committee recommends the following amendments. 1, limit the application of the bill to honorary agents of a foreigner. Exclude the application of the bill to Ugandan citizens residing outside Uganda. Remove the power of the minister to declare any person a foreigner. Remove the restriction on recruitment and employment of a person who are abroad from disruptive activities. Provide for the elements of an offense. Avoid unnecessary bureaucracy in the implementation of the policy. Replace ministerial approvals with the declaration of funds to the relevant regulator. We looked at disruption of financial and economic systems. We also have recommendations. On that one, to safeguard national interests without disrupting financial systems, the committee recommends shifting from broad approval-based controls to a targeted risk-based approach by 1, protect everyday financial flows by exempting personal remittances, routine banking transactions, and legitimate business financing. Replace blanket approvals with disclosure requirements, reserving prior approval only for high-risk activities such as funding linked to political influence. adopting a flexible risk-based declaration system developed with financial regulators and aligned with existing anti-money laundering frameworks. We looked at the vagueness and criminalization of risks. Right Honorable Speaker, we recommend that we align the bill with constitutional requirements of legality and certainty. The committee recommends the following amendments under vagueness and criminalization risks. The committee recommends clearly define all criminal offenses, specifying prohibited conduct and the required intent and the harm addressed. Reduce the penalty of 20 years to 10 years and a fine in the case of legal entity for 200,000 currency points to 1,000 currency points. Limit offenses to conduct that poses a real and a demonstrable threat to national interests, avoiding broad terms that may capture lawful activities. Include measurable thresholds or criteria such as scale or impact to guide enforcement and reduce subjective judgment. Insert a saving clause to protect legitimate activities such as business operations, research, journalism, advocacy, and civic engagement. Introduce procedural safeguards, including enforcement guidelines, written reasons for decisions, and access to administrative or judicial review. We looked at the impact on academia, health, and innovation systems. And we recommend that the academic institutions, research bodies, health and medical facilities legally operating in Uganda be exempted from the bill. We examined the certificate of financial implications because this is a requirement of Public Finance Management Act. We looked at the cost. Right Honorable Speaker, we interrogated it. Actually, the details are there. We concluded that, therefore, since in conclusion, Right Honorable Speaker, in conclusion, the committee undertook extensive consultations, and the views received reveal a shared concern. Across all submissions, there is broad agreement on 4 key points. The bill's objective is legitimate, but the definitions and applications are overly broad. The regulatory approach duplicates existing legal institutional frameworks. Excess power is concentrated in the minister, and the bill's impact could extend across the entire economy. In response to the above and the concerns, we interacted with the learned Attorney General again. And now we conclude that the committee, therefore, recommends that the bill proceed to second reading, subject to proposed amendments attached thereto, and any further improvements this August House may consider appropriate.
Honorable.
Right Honorable Speaker,
I want this part where you interacted with the Governor of Bank of Uganda. Read.
Okay. In response to the concerns, the Attorney General proposed the areas for review which were supported by the Bank of Uganda. The committee has carefully considered these proposals. We have also incorporated these amendments where applicable in the bill. I want to report that yes, we interacted with the Governor Bank of Uganda actually twice. After we had gotten proposals, we flashed to him, and the governor, Bank of Uganda, also agreed with the committee and sent us more amendments, which we incorporated.
Thank you.
I need to report.
Thank you.
I need to report, however, that this majority report that was signed by more than 3/4 membership also has minority reports. In fact, because it's my duty as the reader of the majority report to report the House that we have 5 minority reports. 5 minority reports.
Are there 5?
I beg to report,
Thank you.
Honorable Speaker.
Thank you. Can I have now the minority report? Thank you. Thank you. Thank you.
Right Honorable Speaker, I present this minority report, and we have agreed with our colleagues who also dissented that this will be the order of presentation. I will present first, followed by Honorable Wilfred Niwagaba, to be followed by Honorable Gilbert Olanya, to be followed by Honorable Abdallah Kiwanuka, to be followed by Honorable Betty Namboze, and lastly, the Honorable Medad Segona Lubega. And we have
and the rules of the time still apply.
Before I begin to present, if you may allow, I can address you on that. When a member of a committee dissents singularly, the weight of the report demands that we be accorded the same time frame, Madam Speaker.
Which rule is that? Which rule is that?
Under Rule 215, Sub-Rule 3, it says that a member dissenting or members. And the reasons are in this report, Madam Speaker, you'll see. If I may address you briefly, in the committee...
I am giving you 35 minutes.
This is
all of you. Honourable members, before we continue, we have Honourable Tim Bernard from Maruzi. Welcome, Honourable Tim. And then Honourable Tibiase Peace from Jinja. Welcome. And here, join me in welcoming our new members. Yes.
This is a minority report, Madam Speaker, in substantial dissent of the majority report of the Committee of Defense and Internal Affairs.
Honourable members, can we listen to the report?
And the Committee on Legal and Parliamentary Affairs on the Protection of Sovereignty Bill 2026. This minority report is brought under Rule 215 of our Rules of Procedure of Parliament. In the opening remarks, Madam Speaker, it is critical that today, when a draconian bill is presented to this Parliament for enactment into law, the minority is persuaded by some of the most memorable speeches in the political history of Uganda. Honorable members of Parliament, please pay attention to the contents of this speech attributed to President Yoweri Kaguta Museveni in the early 1990s. This is what he said. I open the quote. Depending on the nature of the state, in a given society, law can be an instrument of oppression and exploitation, or of social justice and progress. Law is not synonymous with justice. It is not always synonymous with justice. It can be, but it may not be. What is legal is not necessarily what is just. Law can be used by the strong against the weak, by the rich against the poor, by the minority against the majority. Historically, law has been used by the oppressor against the oppressed. During the slave trade period, enslaved people were owned and disposed of like chattels, and it was perfectly legal to own a slave. The NRM government is strongly opposed to having laws on our statute books which serve the interest of the minority against the majority of the people, or in which any way promote to serve the injustice or advance backward interest in our society. We close the quote. The minority shall, where necessary, refer to the speech above for the purpose of reminding ourselves as legislators and fellow Ugandans. And 4,
Right, Honorable Speaker. But we want to benefit from the citation. When you're citing, you're quoting somebody, you've stated the date, you could also tell us where that speech was
You
made.
can find the source.
Right Honorable Speaker, I am well conversant with the rules of procedure of this House. That's why I've confined myself to this report. I will be available to clarify if necessary. Members can listen, I will respond to you. Thank you. The minority report, where necessary, shall refer to the speech above for the purpose of reminding ourselves as legislators and fellow Ugandans.
Can I have a copy? Yeah. Me, I don't. Me, I'm analog.
And fellow Ugandans, for we have come from the far, we have come, and the apparent U-turns and reversals that are being made for whatever reasons being advanced, which reasons have no place in shaping the sovereignty of the people of Uganda. Areas of dissent and statement of reasons for dissent. Area 3.1, violations of the rules of procedure of Parliament. Madam Speaker, during the consideration of the Protection of Sovereignty Bill 2026, the co-chairpersons violated several provisions of the rules of procedure of Parliament of Uganda. Rule 135 of the rules of procedure is instructive on reference of a bill to the committee as follows. Sub-rule 1, whenever the bill is read for the first time in the House, the bill shall be referred to the appropriate committee appointed under these rules. Sub-rule 2, the committee shall examine the bill in detail and make all such inquiries in relation to the bill as the committee considers expedient or necessary, and report to the House within 45 days from the date the bill is referred. 3, except in the cases of very minor amendments and subject to Rule 138, all proposed amendments to a bill referred to the committee shall be presented to the committee by the person proposing the amendment, and the committee shall scrutinize the amendment together with the bill. 4, the committee may propose and accept proposed amendments in the bill as the committee considers necessary, if the amendments, including new clauses and new schedule, are relevant to the bill. The minority observes that the committee violated sub-rules 2 and 3 in as far as it did not examine the bill in detail and further did not make all such inquiries in relation to the bill. In the view of the minority, the decision of the committee through a vote on a motion by Honorable Fox Odoi Oyelowo for an omnibus adoption of all clauses of the bill and the amendment by the learned Attorney General without examination and inquiry violated Rule 135. The minority, Madam Speaker, also observed that the Protection of Sovereignty Bill 2026 was proposed by the Minister of Internal Affairs, Major General Retired Kahinda Otafire. Sub-Rule 3 restricts the latitude to propose substantial amendment to only the mover of the bill, which is the Minister of Internal Affairs. Only minor amendments may be proposed by any other person who is not the proposer to the bill. With all due respect, the learned Attorney General proposed 18 amendments, all quite substantial in nature, which amendments the majority unilaterally adopted and relied on to pass the bill in the committee. The committee sought to have rejected the committee ought to have rejected the substantial amendment proposed by the learned Attorney General outrightly. To even make it worse, Madam Speaker, the new amendments were laid before the committee in form of a new bill. Rule 135, Sub-Rule 1, confines the committee to a bill read for the first time in the House and referred to the committee. The committee is stopped from directly receiving bills not read in the House and referred to it by fraudulently bypassing this House and smuggling an amended version of the bill to the committee, an illegality that goes to the root of parliamentary procedure and practice was committed and cannot be cured by any explanation at all. Madam Speaker, the minority further observes that no sooner had the learned Attorney General purported to present the amended Protection of Sovereignty Bill 2026 to the committee at about 12 noon on Thursday, 30th April 2026, than His Excellency the President, through his address to Ugandans at about 4 p.m. on the same day, withdrew instructions from the learned Attorney General. Instead, President publicly assigned Honorable Dennis Amson Obua to ensure that the bill concentrates on what he calls sovereignty of policy decision-making. In the practice of law, there is nothing professional as humiliating as a client withdrawing instructions from you and sharing it out with the public outright. No wonder, since then, neither the Attorney General nor the Minister of Internal Affairs ever attempted to appear before the committee or the House. The House must therefore not entertain the two on anything to do with the Protection of Sovereignty Bill 2026, since the President withdrew the vote of confidence in them. The minority, Madam Speaker, formed the view that Honorable Obua Hamson, having been given fresh instructions as per the written expression of the President, ought to have immediately sought audience with the committee to present the instructions given to him. Was it an instruction to withdraw the bill, or was it, what was it? Despite the insistence of the minority to invite the Honorable Hamson Obua under Rule 135, Sub-Rule 2, to make all such inquiries in relation to the bill, as this was the most expedient, the co-chairpersons, Honorable Kajwenje Wilson.
Honorable Gianna, sorry for interruption. My presumption is that when you bring a minority, you bring your points of departure, not procedure. Flavia, points of departure, not a debate on the procedural ways.
Madam Speaker, respectfully, this is one of the points of departures that I had.
Which one? Which one?
Under subheading 3.1, I said areas of dissent and statement for reasons of dissent as provided in the rules. The first was violations of the rules of procedure of Parliament. And I am explaining under Rule 135 that the committee ought to have examined and on its own move to go and inquire, to make inquiries. And my point is, having come to the attention of the committee that Honorable Obua Hamson was assigned, the committee ought to have moved itself to request Honorable Obua to come and substantiate. It goes to the root of my dissent, Madam Speaker.
So the committee instead went to Honorable Obua. Oh, they should have.
Thank you, Madam Speaker. The co-chairpersons were evident. Madam Speaker, this is important. The co-chairpersons, Honorable Kajwenje Wilson and Honorable Baka Mugabe Stephen, were evidently partial, hostile, and continuously switched off the microphone of members in the committee they perceive to be against the bill. Contrary to the established practices of availing physical copies of submissions of stakeholders to members of parliament at the retreat, members of parliament were instead told to physically get copies to members of parliament. Instead were told that physical copies could not be availed since parliament was on a weekend. The views of Madam Speaker, views of selected stakeholders were instead sent to members on WhatsApp to read on their phones. Members who were not on WhatsApp or whose phones could not open the WhatsApp were effectively denied critical document. Madam Speaker, the privileges of a member of parliament were violated to the extent that some of the members of the committee had to jump on border to travel to Nassau Road to print the stakeholders' document for their own reference. A passionate plea for the committee to adjourn until Monday, when parliament is open, for purpose of printing or photocopying the document was turned down. But Right Honourable Speaker, this gross...
I am rising on a point of procedure. I am rising on a point of procedure, Madam Speaker. A minority report, as per our rules, envisages that a member participates in the proceedings of a committee and then disagrees with some of the decisions taken by the majority. You read. But not to come here and tell us stories, how the committee... So, no. Read the rules. This parliament, while debating reports, is not for storytelling, how members were seated, how they were reading, going on border. What we expect, Madam Speaker, from the minority report is where the member disagrees with the decisions of the majority report, not to waste time of parliament talking as if he's just reading a story. So is the honorable friend of mine proceeding correctly by wasting our time as parliament instead of being straight?
Honorable Dur, Jonah, I am actually enjoying your story. You continue with the story. Please. Let's continue. Let's listen to the story.
Thank you. Right Honourable Speaker, this gross abuse of authority with utmost impunity, laced with shameless sycophancy, is highly condemned. Presiding officers in committees and indeed plenary must be impartial, patient and respectful of the constitutional rights of an MP to represent their constituencies without undue partiality and interruption. I must also add that the co-chairpersons of the committee appeared not to have addressed their minds to the rules of procedure of parliament which guided us, and opted for personal whims to decide substantive points of law as well as procedural matters that arose in the committee. My finding number one is that the proceedings of the committee were held in complete violations of Rule 135 of the Rules of Procedure of Parliament. 2, the co-chairpersons exhibited gross incompetence, lack of tolerance for divergent views, and stifled all avenues of debate during consideration of the bill.
Honorable Dur, incompetence. By the time you come and be a member of parliament in this house, let's tone down our language. Let it be parliamentary. Even when I'm enjoying your story, at least let's be parliamentary. These gentlemen are competent.
Speaker, I don't want to go into the debate, but I could have addressed you on the around competencies. But let me continue. Recommendation. And it's in writing here.
And I will remove it. on the issues of competence.
You are
I'll
such a powerful
remove.
person. Please, Madam
Yes.
Speaker, I respect. Please proceed
Yes,
and remove.
please, you go ahead.
The
I'll remove
minority
that.
recommends to Parliament to reject the majority committee report and instead refer the bill to the executive, or in the alternative, but without prejudice, be pleased to appoint another committee to examine the bill in detail and make such inquiries in relation to the bill in full confidence. Dissent number 2, defective certificate of financial implication. The minority observed that the certificate of financial implications issued by the Ministry of Finance, Planning and Economic Development does not comply with Section 76 of the PFMA and Rule 124 of the Rules of Procedure of Parliament. Section 76 of the PFMA and Rule 124 are at par on the certificate of financial implication of a bill as follows. 1. Every bill introduced in Parliament shall be accompanied by a certificate of financial implications issued by the Minister. The certificate of financial implication issued under Sub-Rule 10 Sub-Rule 1 shall indicate the estimates of revenue and expenditure over a period not less than 2 years after coming into effect of the bill when passed. In addition to the requirements under Sub-Rule Subsection 2, the certificate of financial implication shall indicate the impact of the bill on the economy. Notwithstanding subsections 1, 2, and 3, a certificate of financial implication shall be deemed to have been issued after 60 days. The minority examined the certificate of financial implication issued on 15 April 2026 by the Ministry of Finance, Planning and Economic Development, signed by Amos Lugolobi, MP, Minister of State for Finance, Planning and Economic Development. In the certificate, under paragraph 5 on impact of the economy, the Honorable Lugolobi states as follows: the proposed bill is expected to strengthen Uganda's policy autonomy and national security architecture, improve coherence in the management of foreign aid and foreign funded activities, and support stability in governance and public order. These outcomes are expected to contribute to a more secure environment and implementation of government programs and long-term national development. The minority draws the attention of honorable members to the sad realities that has befallen this country, that the entire ministry responsible for finance, planning and economic development does not know what constitutes an economy of a country called Uganda, and therefore are unable to articulate the impact of the bill to the economy of Uganda. The minority observes that instead of assessing the impact of the bill against well-known parameters such as GDP, sovereign debt, debt to GDP ratio, balance of payments, central bank reserves, interest rates, inflation, exchange rates, rate of growth, etc. Alien parameters form the basis of the assessment. The observation by the majority report that the certificate of financial implication met the statutory standard.
Honourable members.
Let me just put on record.
Yes.
This minority, which I wrote, is actually.
Let's capture all the all what has been in all the minorities.
This is what exactly
so
happened
how much,
in the committee.
let me
that
give
were
you
not
2
heard.
minutes. Let's give you 2 minutes.
This report I have is 40 pages.
Let me give you 3 minutes to summarize.
And in the committee, with the same treatment, Madam Speaker, who are not heard. That's why I'm bringing this issue. I'm appealing to the House.
I have actually given you the same amount of time. 2 minutes. You conclude.
Madam Speaker, I want to put on the record that I cannot conclude in the 3 minutes you have given me, but I appreciate it. If it is your ruling that this report stops at this level, I have no problem. I respectfully submit, and then I can leave, because there is no way I can. And I wanted just to finally, because as you also know, this may be possibly the last time some of us may be in this parliament. So I wanted you to protect that constitutional right, that little window that the people gave me to be in this house, to represent them. I just plead of you. I may not come back ever. But that constitutional right for me to present, I wanted to ask that you give me.
Jonah, because you've actually spent the 35 minutes. Now, Jonah, I have always told you you're one of the people I will miss in this house. I am giving you an additional 5 minutes, and all the other minority reports, we will capture what is in your minority report, because the time has been taken.
Yes. Yes. You might your reports. They might their reports.
Right Honorable Speaker. Thank you so much, Right Honorable Speaker. I want to now go back to the report, but let the record capture that when I appeared in the committee, and you have designated me, Madam Speaker, as a member of Parliament to sit in the committee of the legal. In the joint committee, I was not given the opportunity. The same treatment, and that's why I thought this house would allow me to present. So with that, let me just put on the record that that the 5 minutes that you have given to me is not enough for me to present this, and I thank you, and probably take the opportunity to conclude by wishing members who are going to return to the 12th Parliament good luck in their deliberation and representations. I know next week people are going to swear in. I want to wish you all the best. But without prejudice, if the committee proceeds to committee stage, there are amendments that are also attached here.
Yes.
I beg that I will be given time to move those amendments, Madam Speaker.
So you're putting a motion for committee stage so that we do the amendment?
Let the record capture that I did not. I just put you on note because I'd written it here.
No problem, no problem. We shall consider
If you had been patient and read, it was going to come in the last page.
No, I am not impatient. Honourable members, I gave each side 35 minutes.
Yes. Right Honourable Speaker, I believe you will give me my right as a member who prepared a minority report that was co-signed by 2 other members, Honorable Etteka Ann Ebaju for FDC, District Woman Representative for Soroti, and Honorable Asumani Basalirwa, the MP for Bujiri Municipality. And my Right Honorable Speaker, our points of dissent are in the following areas. 1, the provisions in the bill that tend to infringe the freedom of expression contrary to Article 29 of the Constitution. 2, the inconsistent mens rea, since several offenses of comparable severity, particularly clauses 8. Incidentally, this particular microphone seems to have been tampered with, and mine has, so clauses 8, 10, and 12, and 22 that remain strict liability, while others require intentional knowledge, and creating an internal inconsistency contrary to Article 28(3) of the Constitution. I hope the answer will capture me. Yes? At statutory number 3, statutory definitions in respect of foreigner and agent of foreigner, which cross-refer to clause 2, which in itself raises
Wilfred, that we will discuss that at committee stage. I will allow you to bring your issues.
Number 4, Right Honourable Speaker, is on criminalization of free speech. Number 5, and most importantly, Madam Speaker, this particular bill tends to infringe Article 1 of the Constitution by, one, trying to invert the sovereignty of the people into the sovereignty of the state. Article 1 of the Constitution refers to the people of Uganda being sovereign. What the state has is the authority to administer. So the title of the bill itself tells the lie about itself. And when you go through the bill, Right Honorable Speaker, apart from clause 5, which talks about the sovereignty of the people of Uganda, the rest of the clauses are in respect of the sovereignty of the state.
Okay.
And when we go to committee stage, Madam Right Honorable Speaker,
So we are going
have many amendments to make.
No problem.
Since we were never given an opportunity in the committee stage,
Thank you.
we have amendments to make on almost all clauses in the bill.
Thank you.
May I invite my other colleagues who have minority reports to make their
Members.
presentations.
Members.
Thank
Madam Speaker, I have something to tell you. Madam Speaker, in my capacity as the Shadow Minister for Internal Affairs, I went to the committee with a request to make a presentation. Madam Speaker, I happened to arrive before the Attorney General. The chairman of the day, Honorable Baka, requested me to wait for the Attorney General to present so that I could also be given time. After the Attorney General had made his presentation of amendments, Honorable Baka ruled that I will make my presentation while at Munyonyo. When we reached Munyonyo, Madam Speaker, Honorable Kajenje ruled that my request had been overtaken by events. Madam Speaker, I chose to write a minority report because the issues I was going to raise had not been raised by anybody else. So I wrote a minority report, Madam Speaker. Madam Speaker, you are now ruling that there is no time. Madam Speaker, as a member of the committee, I'm not supposed to debate. Madam Speaker, there was a memorandum that came from Buganda Kingdom. Madam Speaker, when we reached Munyonyo, the memorandum went missing. Madam Speaker, they have told you here. Let me tell the Speaker. Madam Speaker.
Honourable members, give Betty time. Some order.
Madam Speaker, I've heard the chairman telling you that when we were at Munyonyo, we heard from the Governor Bank of Uganda. And you know, Madam Speaker, I was so surprised because while the rest of us were in Munyonyo, we were never informed that even the Governor of Bank of Uganda had gotten back to us. Madam Speaker, because of those many issues, we are also told that 700 people sent memorandums to the committee, but only 47 of them were accounted for. I feel so silenced. Is it your ruling that the people from Mukono should not be heard on this?
Honorable Betty. Honorable Betty, my sister. The people of Mukono have been heard. You've spoken for over 5 minutes. You've raised your issues, and we are going to address all of those issues. Honorable members, we have all these supplementaries, and not supplementary, but minorities. we are going to go committee by committee. And all of you are saying you have issues on each clause. Why don't we look at clause by clause? Honorable Odur has raised pertinent issues. Let's look at.
Madam Speaker, let
Yes,
the record be clear.
Honorable.
You denied me opportunity to present. Don't use my name. Don't use my
Honorable
name.
Ogun.
No, don't.
Honorable Odur, you took all the 35 minutes. Honorable. Honorable Lanya.
Right, Honorable Speaker.
Honorable Lanya, let me give you 5 minutes.
Thank you, Right Honorable Speaker. Right Honorable Speaker, I'll go straight to the point of dissent. Right Honorable Speaker, the minority, following Rule of Procedure 105 of Parliament, Right Honorable Speaker, the bill establishes an extensive regulatory and criminal framework governing individuals and entities classified as agents of foreigners, imposing control and funding policies, policy engagement, and civic participations. The minority observes the several provisions, raised several concerns, including the vagueness and inconsistency of definitions, an extreme and disproportionate penalty regime, infringements on freedom of expressions and civic space, duplication of existing legal framework, and the absence of commencements and the transitional provisions and duplications of the existing legal framework. Right Honorable Speaker, when the committee engaged with many entities, you recall we engaged with about 53 entities. Out of the 53 entities, 52 were in support of this bill. 51, including Bank of Uganda, religious leaders, among others, were telling Ugandans that this bill, when passed, it will create economic instability in Uganda. That was the word from the governor of Bank of Uganda. Right Honorable Speaker, this bill, it creates extreme and disproportionate penalty regime. The bill establishes a uniform and severe penalty structures, imposing custodial sentences of up to 20 years in prisons across wide range of offenses. Notably, the same maximum penalty applies to promotion of interest of foreigner. If you look at clause 5. Right Honorable Speaker, participation in activities deemed to promote foreign policy. That is in clause 10. Publication of information characterized
Gilbert,
as
we have
economic
now
supplement.
gone. We have gone to clauses. Eh?
Thank you, Right Honorable Speaker. Right Honorable Speaker, because of time, let me go straight to the recommendation. Right Honorable Speaker, this minority came out with the following recommendations. Having engaged and got many views from Ugandans, the minority recommends that the House does not pass the bill in its present form. 2, the bill be withdrawn and remitted for comprehensive redrafting. 3, a revised bill should provide clear and precise definitions, establish a proportionate penalty regime, align with existing legal frameworks, be supported by a credible economic and physical analysis, and finally, be subjected to broad stakeholders' consultation. Right Honourable Speaker, the view of the minority is that the bill should be withdrawn. I beg to move.
Honourable Betty. Betty, 5 minutes.
Thank you, Right Honourable Speaker. Right Honourable Speaker, the points of my dissent are as follows. 1. Right Honourable Speaker.
Switch on. Switch on.
Right Honourable Speaker, it is my opinion that there hasn't been enough public hearing according to this bill. Right Honourable Speaker, you have been told that 57 memorandums were reviewed. But the fact of the matter, Right Honourable Speaker, is that the committee received over 700 memorandums. One of them, Right Honourable Speaker, as I have put it, being from the Buganda Kingdom. Right Honourable Speaker, when we went to Munyonyo, we are given time to go and study these memorandums on WhatsApps, but when we returned to the committee, Right Honourable Speaker, the committee did not give us time to make a presentation, as I've told you before. Right Honourable Speaker, it's not about allowing people to come to the committee. The purpose of the people coming to the committee is to give their opinion space that the people should be heard. But we are handling, my point of dissent is that the committee ruled in favor of only 2 people out of the 700 who opposed the bill, Right Honourable Speaker. Right Honourable Speaker, we are here fidgeting with time. This is not legislation. The committee is always given up to 245 days, according to our rule of procedure 135.
Not 200.
45
days. But if you get a committee which is efficient like yours, it can even do it.
It wasn't efficient, Madam Speaker. Even the problem of time can even be seen while we are here, Right Honourable Speaker. Right Honourable Speaker, my request is that the 11th Parliament stops behaving as if it is the last Parliament Uganda will ever have. There will be other parliaments that will come after this Parliament, Right Honourable Speaker. And Right Honourable Speaker, we are so honored that you will also be in that next Parliament, Right Honourable Speaker.
No, I can.
My recommendation, Right Honourable Speaker.
I can choose not to be because I have.
You already there because we have been talking to Mau.
How has Mao come here? Order. There's an order here. There is an order.
Right Honourable Speaker. Right Honourable Speaker, we are discussing a very important bill. And I'm wondering how Honourable Member is talking about their discussion out of this House. Is it in order to bring the name of somebody on sovereignty bill that we are discussing? Is it really in order?
Do you want to tell us is that he's an agent of foreigners? No, the person they mentioned the name. Yes.
Right Honorable Speaker.
Betty, finish.
Right Honorable Speaker, the other point of dissent is on the issue of interpretation, Right Honorable Speaker. The law refers to the interest of Uganda. However, when you go into the interpretation, the interest of Uganda has not been defined. It also talks about the interest of the foreigner, which is also undefined. It also talks about government policy.
That is on interpretation
on
clause.
Interpretation, Right
so
Honorable
you will
Speaker.
bring your idea when we are in that clause.
I thought, Right Honorable Speaker, you had allowed me to present my report.
No, what I'm saying, we will expect your idea on that clause, what you think, the amendment you want.
Madam Speaker, first of all, I'm a member of the committee who is not supposed to contribute to debate.
No.
Two, Right Honorable Speaker, you gave me an opportunity to make a presentation.
Honorable
and
Betty,
I was so thankful that
Honorable
you gave me
Betty, I am only advising you that when we reach that clause, I will still give you chance to bring in. So you read your report, but I will still give you chance to bring your proposal.
My recommendation, Right Honorable
Are we speaking
Speaker.
the same English?
Madam Speaker, I'm reading the report and you are giving me advice. I take your advice, Madam Speaker, but I continue to read my report.
You read. Yes.
I seek for your protection.
You finish. You continue the report. Continue.
I seek for your protection.
Members, yes, there's an order from WOPA. Order from WOPA.
Thank you, Right Honorable Speaker. Right Honorable Speaker, I want to request. Right Honorable Speaker, there is a lot of noise, and yet the microphones that they are using is not as loud. So, the point of order that I'm raising is that, is it in order for members to make noise when a member is submitting? Is it it's okay to laugh, but let us laugh and allow the member to read her report? We now can't hear what she's actually reading. So, Madam Speaker, is it in order for members to continue shouting when a member is actually reading her report?
You are the one who was shouting. Honorable Betty, can you? Let's hear Honorable Betty. Members, can we listen to Honorable Betty? It is on. Switch on.
Thank you, Right Honorable Speaker. I don't know why this particular microphone is low.
Please go ahead. At least I can hear you.
Right Honorable Speaker, my suggestion, my recommendation is that this bill is withdrawn by the movers to give Ugandans time to make meaningful contribution to the debate and to accord the Parliament enough time to handle a bill of this nature. Right Honorable Speaker, the Commonwealth practice is that parliaments which are about to retire don't handle controversial business. It's a practice, Right Honorable Speaker, and we are part of the Commonwealth, Right Honorable Speaker. The fact of the matter, Right Honorable Speaker, why that is required.
Which page are you in?
I'm reading page 3, Madam Speaker.
I'm not, and I'm following your report.
Madam Speaker, I move that this House finds that this bill violates the Constitution, rules of procedure, and the Parliamentary Convention, and that this House declares that the denial of the main report offends Rule 245 and 215.
214 and 215.
214 and 215. That it also declares that clause 2, 3, 5, 8, 11, 12, 24, 25, 30 are void for vagueness and the unlawful delegation of powers. That this Parliament rejects the joint committee report by the majority. I therefore also recommend that the movers of the bill withdraw the bill under Rule 141, defer the subject to the 12th Parliament with proper consultation, direct that any future bill must affirm the sovereignty in the people under Article 1, define all key terms.
First of all, Rule 141 is on procedure
141. Rule 140.
Sub-Rule 1.
Sub-Rule 1. That directs that any future bill must affirm that the sovereignty belongs to the people under Article 1, and that key terms in the bill are properly defined, that is, the interest of government, the government policy, what constitutes the actions that make one an agent of a foreigner, and that the minister is not given powers to alter the offences under the bill as it is in the bill, the law as it is in the bill. Madam Speaker, in conclusion, it is my prayer that the protection of the Sovereignty Bill 2026 fails the test of the constitutionality, legality, and procedure. The 11th Parliamentary Final Act should be to affirm the supremacy of the Constitution, not to legislate excessively. I so pray.
Thank you. Thank you. Yes, there is procedure matter from
Right Honorable Speaker, I want to thank you for the opportunity that you have given to those with the minority reports to present. It is in the interest of this country that all the voices of Ugandans are heard in this House. And those who have spoken represent those voices. Right Honorable Speaker, Honorable Jonathan Odur did say he wanted to make a presentation in the Munyonyo, but he didn't have enough time. Or he was not given the opportunity. And now that he has very, very, very many issues that he would love to present, together with the rest of his colleagues, and those who may feel there are procedural matters that were not handled well, but now we have the opportunity to look at this bill in a proper detail, provision by provision. I beg to move procedurally.
So what have you spoken?
I therefore want to...
I am asking, what have you spoken?
Kiwanuka.
Kiwanuka.
I'm raising a procedural matter.
Kiwanuka.
Thank you, Right Honorable Speaker. Briefly, but my approach was different. The point to which
Let's have
Right,
order.
Right Honorable Speaker. Notwithstanding the matter in which those amendments an affront to the past precedents of the House, of the bill proposed additional amendments totaling to 24 out of 30 that are being proposed to this to the past ruling of the presiding officers of the Public Service Pension Fund Bill, then directed the withdrawal of the Public Service Pension Fund added various precedents, including the hazard of a bill in reference to the Sexual Offences Bill 20. Minister to withdraw the bill and incorporate the proposals in the Service Pension Bill 2023. I guide that if the bill, incorporate the proposed amendments and have the bill go and incorporate the proposed changes, gazette it, very critical amendments made in regard to this matter of the bill. The minority wish to note that the amendment if agreeable amend the bill and reintroduce it for the minority. Indeed, the Right Honorable Deputy Speaker, while directing issues in the minority report and those in the majority report, their views and incorporate them into the virtue of Rule 8(2).
In light of the above, the minority calls upon the presiding Speaker. The Speaker's ruling form part of the rules of procedure of
misquote the ruling of the former deputy 'm in the bill in detail and make all such inquiries after 5 days, working days from the date of the bill. An alteration on the object of the bill and a meant was an alteration.
Invite the honorable colleagues to in one way or the other. Honorable Speaker, as the President of the Republic of Uganda, in the letter he wrote,
Parliament who is holding the bill.
the minority, right, Honorable Speaker, as I'm concluding, the minority notes that being Asimwe John, the resident of Fort Portal, gave directives in his letter over his, which was a statement. I call upon this House Action of Sovereignty Bill 2026 that was read for the first others which have been left behind. The report is real societies, and the government undertakes to the rules of procedure be amended. Thank you, Right Honorable Speaker.
Thank you, Right Honorable Speaker. When it comes to making our laws when they present their view. Of Buganda Kingdom.
I have
got lost.
I have not opened the debate yet.
Answered. It is bad. Yes, we want it to be withdrawn.
Honorable Daddy, you have only
and that I taught some people because you are the speaker, but and therefore saying all of you minority even where you, Right Honorable Speaker, more than the time you had already by age, among other things. I am with that said, Right Honorable Speaker, let me to avoid repetitions. I did not read any amendment. I know he skillfully wrote in small words. However, I treat them as views of the reasons for my dissent. Insufficient concern of Article 1. The bill is accompanied the any mischief. At page 2, to read, but with emphasis on Article 1. Ugandans have no views to contribute on such an important See clause 7.4 of the bill. It is and others versus Attorney General constitutional petition goes to the root of our constitutional governance. In three the elaborated submissions of my colleagues does not cure any mischief and is therefore misconceived. And the summary it is and agents is the mischief. That this has given external donors, I understand, platforms by foreigners and agents of foreigners to that the bill is misconceived since it is based on government's policies and programs by foreign countries and agents of use of online platforms. I note that one, laws which include, among others, the NGO addition, I note that the bill further is misconceived. The majority report was uploaded yesterday. It's a regulatory arbitrage by extending the bill including the political sector, which is so to be. And colleagues, although the bill seeks to safeguard the sovereign an agent of a foreigner who registers with the minister Clause 7 can implement government policy under Clause activities that are allowed for an agent of a foreigner under the bill. What is offensive to the Constitution becomes lawful since foreigners. The so-called acts allowed under the minority note, therefore, that the bill had declared void for vagueness and the stretching beyond Article 1. I also opine that it offends canvassed in Paul Semogere, Zakalo Luma, and Juliet Rayner Kafiri constitutional, since it had the effect of amending Article 20 been passed without following the procedure under and 3 of Article 97 within and I'll proceed to page number 1, unconstitutional deprivation to reintroduce the foreign element against freedom of expression under attack. Conscience and belief. Now clauses 5, 7, 8, 9 in association and engaging or participating in a riot or system. Clause 13. These restrictions are neither cannot permit any limitation of the enjoyment of the right freedom of association and assembly threatened. To influence the policies through civic organization. And in some places, extinguish that right. (21)(1) all persons are equal. I accede to that. Then the foreigners and their the right to privacy of a person and property and no to inspect the premises wide and arbitrary provision. Authorities to look Act, Charles Onyango Bo and another versus Attorney General of Uganda. I think Honorable Namboze has hinted on it. Acts at the order requests under the at page 14. Now the foreigner clause, I think Right Honorable Speaker, I have highlighted the bill is accompanied with a defective certificate on the following areas. One, that when passed, the impact of the bill on the economy without telling us what we are likely defective and cannot support this bill. And I associate in the same terms. Inconsistency and the voluntary shocks are excessive and disregard the precedents of the House. Finally, Right Honorable Speaker, for my reasons, and here nobody will ask me whether stakeholders in the committee that the committee engaged with. I think only 3 people supported. 3 stakeholders. And the gentleman from Fort Portal, initiated in cabinet. But it does not stop there. Received the president's instructions. Only the and not the minister.
Honorable David.
So, Right Honorable Speaker, and therefore there is no need for firefighting. And behind the curtain of sovereignty and security. Democratic tenets, constitutional commands, and injurious to for recommend as follows. 1. The entirety for the reasons stated above. To fight for us. Medad Lubega Segona, MB.
Yes, motion.
Right Honorable Speaker and Honorable colleagues, of the minority reports. States, a member may for the House. I therefore and 214 sub-rule report on the bill and the debate.
Odoi Kabanda, Honorable Akelo, General Ibanda, Omara, Chu Eric, Gabriel, Toroma, Ombugisu, Maxi, by the whole Yusuf Sibambe. Honorable, all the elders.
One is that Rule 2 under Rule 17, Sub-Rule 4, is that this particular report and I believe with the turn up you have in is that the members basing on the 3 reasons I justify Right Honorable Speaker.
Thank you.
It is apparently clear that the minutes of the committee meetings and even
how many members have reported to you that they have
of course, you know, the presentation has not been to have not had time to look at the reports, read them. Three, most importantly, Right Honourable Speaker, this particular bill it is important that members be given time to debate. So I do strongly oppose the motion.
Right Honourable Speaker, I think the question has been passed to read quickly, which I strongly oppose, because I think it's about agents of foreigners.
Members, I put a question that Rule 20 the report of the Committee of Protection of
Right, Honorable. Of our rules of procedure provides for division. And immediately 40 or more members stand in their places. The ayes have it. So these are more than 40. The rules, you need to start reading the rules. Yes. So, Madam, I'd like to implore you that we do the casting by division.
Honorable. Nobody will. I will not speak before you.
Right, Honorable Speaker. The rule says you.
Honorable members, I don't need to ascertain. And then we see. And one thing I can tell you, whether we a point for eyes, the eyes can